American Advantage Law Group is proud to bring you this webinar.
The legal issues involved with buying a restaurant. Before you buy, figure out why the restaurant is for sale. Is the owner going bankrupt and merely trying to cut his losses? Check all books and records to see if anything is suspicious. Has the reputation slipped? Check the demographics to see if the area cannot support the restaurant, or if there is stiff competition in the area. Make sure you do your research and understand exactly what you are buying. Check the existing conditions of the restaurant. Check to see how much employees are being paid. Check all equipment to make sure everything is in working order. Check for purchase records and warranties on all equipment. You want to make sure the owner actually owns everything. Obtain information about existing problems or potential problems from a legal standpoint. You will probably not be allowed to sell the same type of food as an existing restaurant nearby. Ensure that any obligations and loose ends from the previous owner are complete. Any promises made, representations, and warranties should be written down in a legal document. Understand the character traits of a successful entrepreneur. Obtain legal assistance. Allow sufficient time for all such matters to be completed. A general rule of thumb is approximately 6 to 8 weeks, depending on the complexity of the issue. Financing. It is imperative that you plan for not only financial requirements involved in the purchase, but costs that will incur shortly after the purchase. These include the deposit amount, the portion of the purchase price that is payable on the closing date, monthly payments, operating line of credit for day-to-day operations, and operating expenses such as cost of food, wine, employee salaries, and etc. What if I don't have enough cash? Without enough cash to satisfy the purchase price on the closing date, you may wish to ask to pay over a specified period. Example, a certain amount of money every month for 3 years after the closing date. This financing agreement will need to be documented by a separate promissory note. Assets or shares. There are 2 ways to legally purchase a business. The first is an asset purchase. You are actually buying everything of the business from the seller: the equipment, the naming rights, the logo, internet domain name, supplier list, and etc. The second is a sale purchase. This is when the seller is a corporation and you are not actually buying any particular assets, but rather shares of the corporation. There are advantages and disadvantages to both. The right method for you comes down to specific legal, accounting, and insurance issues particular to your circumstances. The purchase and sale agreement. This is the key document which the transaction will follow. It ensures that all obligations of the parties, promises made, and representations and warranties made by the seller to the purchaser are written down in a formal document. Do not rely on verbal promises at any time. Provisions in the P&S agreement. List of assets and a representation that the seller owns the assets. List of excluded assets and excluded obligations. Purchase price and terms. Closing date, which is when you will acquire legal ownership of the assets or the shares. Representations and warranties, statements and promises made by the seller to the purchaser. Special agreements by seller. Remember, this is a legally binding contract. You may not be able to change your mind after you sign it, depending on special conditions included. Licensing. Get in touch with your local license department. Zoning requirements, which will check location for your business and that your building is suitable. The fire department for any regulations that will include flammable materials, ovens, stoves. Other potential regulations including parking, signs, and lighting. And finally, the health department about potential food regulations. Go to www.abc.ca.gov for the California liquor license. The non-compete, non-solicitation. As a purchaser, you may want to restrict the seller from operating a competing restaurant nearby, hiring away existing employees, or directly contacting patrons and having them follow the seller to a new location. Don't be swayed by pressures from the seller, who may want to close the deal as soon as possible. The L-1 visa document. This is a non-immigrant visa granted for the purpose of working in the United States. For restaurant owners, the L-1B is relevant. It is specifically for workers with specialized knowledge. It is valid for 5 years, and it can be used as a stepping stone to a green card. Depending on how large your company is, the regular L-1 visa or the blanket L-1 visa may be applicable. The regular L-1 visa must be applied for and approved for by each individual by the U.S. Citizenship and Immigration Service. The blanket L-1 visa is available to employers who hire a large number of foreign employees every year. Dual intent is allowed. There may be intent to immigrate to the United States